All right, sorry about that. Yeah, we're gonna get underway now.
I'll just have to go without it.
Okay, sorry about that.
Hello, everybody. All right. Let me begin by welcoming you to the Attorney General's office. I'm Peter Narona, the Attorney General. With me is Marion Weisenbaum, the Chief of the Civil Division, and Nicholas Vaz, who's in our Environmental and Energy Unit. Not with us, but someone who had a big role in this is Sarah Rice, who's the Deputy Civil Chief and in charge of our Public Protection Bureau. So we're here today to announce the status and frankly the resolution of our litigation involving the purchase of Narragansett Electric by PPL from National Grid. And I'm going to spend some time with this today because this is an incredibly important transaction for Rhode Island. Public utilities are certainly complex. I think because of that complexity, sometimes all of us collectively in the public and government, our eyes tend to glaze over. But this was a really important matter for the people of the state of Rhode Island in a lot of ways. So I'm going to really walk us through how we got to where we are today. The bottom line is as a result of our litigation, we have secured over $200 million in value for Rhode Islanders. We've ensured an adequate storm response should that happen, and we all know that it will. The history is pretty clear about that. And we are also advancing our climate goals. I want to point out that the agreement that we reached with PPL and National Grid, specifically PPL, to approve the sale or withdraw our objection to the sale, the benefits and protections afforded to Rhode Islanders significantly exceed the DPUC conditions which the Division of Public Utilities and Carriers put on the sale when they approved it earlier this year. There's, as I said, $200 million in value for Rhode Islanders. I'll get into the details about that. Concrete action on climate mandates and investments, which were ignored by the DPUC. And as I said earlier, there are provisions for an adequate storm response. Most importantly, the agreement that we reached today is enforceable in court. And so if PPL, as the new owner of our public utility, does not do what it's agreed to do, we will go to court to enforce it. So a little bit of background here. Again, I think the background is important to fully understand the scope of what we're talking about here. National Grid delivers electricity and gas in New York, Massachusetts, and Rhode Island to over 20 million customers. They operate in Rhode Island through Narragansett Electric. I want to point out 20 million customers because we're going to compare that to PPL. Narragansett Electric has a functional monopoly over electric and gas operations in Rhode Island. They have 486,000 electric customers and 257,000 natural gas customers. So as we've seen in other contexts in this office, health being one of them, when there is a monopoly, it's particularly important that state regulators, and in this context, the Attorney General as an advocate on behalf of the public, pay close attention so that we can protect the interests of all Rhode Islanders. PPL Corporation, Pennsylvania Power and Light, is an energy company headquartered in Allentown, Pennsylvania. It delivers electricity to customers in Pennsylvania, Kentucky, and Virginia. It delivers natural gas to customers in Kentucky. It has 2.5 million customers. So it's significantly smaller than National Grid, particularly as it pertains to storm response. That was a real concern to this office. The ability to surge resources when we need them most from a much smaller company. So the background of the proposed transaction is essentially this. In March of last year, 2021, PPL announced plans to purchase Narragansett Electric from National Grid for $5.3 billion. In May of 2021, PPL, National Grid, and Narragansett Electric filed a petition seeking the necessary approval from the Division of Public Utilities and Carriers, or the DPUC. I'm going to stop there just to make a point of clarification. There is something called the Public Utilities Commission, and then there is something called the Division of Public Utilities and Carriers. What this transaction needed approval from was the Division of Public Utilities and Carriers, not the PUC itself. So under Rhode Island General Law, Section 39325, the DPUC is required to find that the facilities for furnishing service to the public will not be diminished, and the terms of the transaction are consistent with the public interest. So service to the public will not be diminished, and the terms of the transaction are consistent with the public interest. Now, I would argue that is a broad standard. It gives any regulator and advocate broad leeway to advocate and decide matters in a way that benefits the public. Service to the public will not be diminished. The terms of the transaction are consistent with the public interest. On June 24th, this office filed a motion to intervene in those DPUC proceedings. We did that to ensure that the interests of Rhode Islanders would be protected. There were a number of ways that we could do that in our capacity as I could as Attorney General, or the office could. One way is through our statutory authority as the environmental advocate of the state. Pursuant to the Environmental Rights Act, we have the statutory authority and obligation to take all possible action for the protection, preservation, and enhancement of air, water, land, and other natural resources located within the state. We have other powers as well, but that's just one of them. We had fellow interveners. I'm really grateful to these fellow interveners for their advocacy in the context of those proceedings. One is the Acadia Center, the Conservation Law Foundation, the Green Energy Consumers Alliance, and the State Office of Energy Resources. I also wanted to extend my thanks to the advocacy section of the DPUC. So within the DPUC, they actually have an advocacy section, and they were involved in those hearings as well. And I would argue that their work was outstanding. They agreed with us, not the hearing officer of the DPUC, but their work was outstanding. It was not until August of 2021, and only after hearing that the DPUC allowed this office and our fellow interveners to intervene. This office, along with the other interveners and the DPUC's own advocacy section, participated in 4 days of hearings before the DPUC in December of 2021. And those hearings followed extensive discovery on a relatively short timeline. At the conclusion of those hearings, this office, the other interveners, and the DPUC's own advocacy section asked that the DPUC deny approval of the proposed transaction. These were some of the concerns. We were concerned that by severing Narragansett Electric from National Grid's regional system of shared services in Rhode Island, Massachusetts, and New York, that could result in new costs or transition costs that could be borne by Rhode Island ratepayers. We believe that there was insufficient evidence in certain areas, like storm response, to show that PPL ownership would not diminish, remember that's the phrase, diminish services, or substantially increase costs for Rhode Islanders. There was insufficient evidence to show that the transaction was consistent with Rhode Island's Act on Climate. That Act on Climate requires all state agencies, including the DPUC, to conduct their business and make decisions with the state's climate goals in mind. On February 23rd of this year, the DPUC granted approval of the transaction over our objection. Following the approval, National Grid and PPL, as one might expect, quickly moved to attempt to close the transaction, to get it over and done with, to block off any legal avenues that we might pursue to change the dynamic. This office filed a motion to stay the transaction and an appeal of the decision in the Providence County Superior Court. Why did we appeal? There are a lot of reasons. First of all, the DPUC, in approving the sale, did so under a new and incorrect minimal legal standard that ignored Rhode Island law and its own previous decisions. The DPUC declared that its review of the sale did not prescribe or justify an evaluation of post-transaction rate impacts. Translated, post-transaction rate impacts aren't relevant to our decision-making process. The DPUC failed to compare pre- and post-transaction services and rates, and the DPUC expressly ignored the Act on Climate's command to consider the climate impacts of the transaction. So on April 1st of 2022, Judge Stern granted our motion to stay, and he found that this office had a reasonable likelihood of succeeding on the merits, showing that the hearing officer improperly approved the transaction without properly considering whether it was consistent with the public's interest. Again, diminished services consistent with the public interest. As Judge Stern stated, the hearing officer had, quote, failed to meaningfully consider the transaction's direct impact on ratepayers. Now this I found very interesting at the time, and it remains interesting to me today. As Judge Stern noted in his decision granting our motion for a stay, the hearing officer, in granting approval to this transaction, ignored the same standard he himself had used in a case in 2006, in the Southern Union case. Again, as Judge Stern pointed out, in Southern Union, the same hearing officer, in determining whether the transaction was consistent with the public interest, considered the transaction's impact on low-income ratepayers. Those are Judge Stern's words, not mine. In National Grid PPL, this transaction, however, the same hearing officer stated that determining whether the standard for approval is met must be based on an evaluation of the proposed buyer's ability to provide utility services. Comparing the utility's respective operating costs for providing such utility services is not a valid prerequisite under this approval standard. So think about that for a minute. In granting our approval, where the standard is it in the public's interest? We don't need to get into comparing operating costs pre and post transaction. I would argue that interpreting this law that way is not in the best interest of Rhode Islanders. Judge Stern also said, this would seem to suggest that considering the potential for increased costs is immaterial to determining whether the transaction in question is consistent with the public interest. Judge Stern's words, not mine. However, the hearing officer in Southern Union considered in detail the economic impacts the proposed transaction would have on low-income ratepayers, as well as the impact on environmental remediation costs. So the sands moved under our feet in this case. Judge Stern in National Grid, the hearing officer held that consideration of ratepayers specifically is no longer necessary because ratepayers are included within the general public. And the general public's interest, according to the hearing officer, denotes a generalized, harmonious relationship with the public as a whole. If you can tell me what that means, I'd be grateful. Judge Stern, compared to the Southern Union standard, this is not the same standard, nor clarification, but an entirely new standard. And what drives this entirely new standard? Convenience for the utility companies. That's what the hearing officer said in his decision. The division also believes further clarification is needed, meaning this new standard, to discourage attempts by future parties, that's your Attorney General among others, to define public interest so narrowly and subjectively as to render all Section 39.325 reviews unduly time-consuming and expensive to adjudicate and unduly burdensome to the energy companies. Think about those words for a minute, what they mean for Rhode Islanders. To the hearing officer, to establish this new standard of generalized, harmonized relationship, all that matters is the utility company's fitness, willingness, and ability properly to perform the services proposed. Translated, are they in the black? Meaning, do they have money? Do they know how to deliver energy? They can do that. That's all that's required. Notwithstanding, there's an opportunity under the statute to make sure that services aren't diminished and that the transaction as a whole is in the public's interest. To the hearing officer, are they in the black? Do they know how to deliver energy? Judge Stern, response to that statement said, notably, the hearing officer herein makes broad sweeping statements without any citation to statute, case law, or applicable regulations to support these propositions. Judge Stern's words, evidently, the hearing officer desires that the approval process be streamlined because he believes it is unduly time-consuming and expensive to adjudicate and places an undue burden on the energy companies. I would argue we should be asking ourselves, what undue burden in terms of our rates and in terms of our climate, and in terms of our health are we placing on Rhode Islanders? That's the question. Judge Stern, however, the transaction is one of the largest transactions in this state's history at approximately $5.3 billion, impacting a large portion of businesses and residents within the state. So thus, according to Judge Stern, again, his words, not mine, although this court agrees that efficiency is an important consideration, and who could argue with that, efficiency cannot be prioritized over the level of diligence required for a transaction of this magnitude. Folks, this is a big deal. We're giving the monopoly on energy in Rhode Island to somebody else. We have an opportunity here to get it right for Rhode Islanders, now and in the future. The time to act was now, not later. So the standard was wrong. The bottom line is that the impact on ratepayers should and does matter to whether this transaction should have been approved by the DPUC. As Judge Stern pointed out, the hearing officer failed to make any determination that ratepayers would not be unfavorably impacted by the transaction. Judge Stern also said the hearing officer characterized issues related to ratepayer risks as inappropriately before the division and consequently refused to consider such risks. The hearing officer was plainly wrong. While the Public Utility Commission, according to Judge Stern, as he wrote, has the authority to set utility rates, the division has the authority to assess the impact of those potential rates on ratepayers. When considering whether the transaction, those words again, is consistent with the public interest. And there's clearly a difference between actually setting the utility rates, which the PUC does, and considering the effect potential utility rate increases in costs may have on ratepayers. Judge Stern, the hearing officer was incorrect. While the division is not authorized to set specific utility rates, the division is charged with considering ratepayers in the approval of not only this transaction, but other similar transactions. So, as Judge Stern found, the Attorney General has demonstrated a reasonable likelihood of success in the merits as it relates to this decision because of the hearing officer's reinterpretation of the statute and failure to meaningfully consider the transaction's direct impact on ratepayers. Act on climate. Before I get to that, I spent a lot of time just going over Judge Stern's decision. Why? Because one of our biggest problems with the DPUC's decision was it used the wrong legal standard. It applied a legal standard that gave the minimal amount of protection to Rhode Islanders rather than one that could give the maximum protection. It had those two options under the law and under the statute. It chose the minimal one. It departed from the own standard he had used 20 years earlier. Act on climate. Look, the Act on Climate is important and it's real and it matters. And until we as a state recognize that, take action, specific action, with that kind of urgency in mind, we're not going to meet our goals. Okay, we're not going to meet them. You know, in government, we have this tendency to keep everything right here in front of us. You know, none of us are going to be here forever. I'm talking about in office. And so we tend to focus on what's right in front of us. Act on Climate needs us to think about the future, but act now. And in issuing the approval of this transaction, the hearing officer, in our judgment, essentially ignored the Act on Climate. Judge Stern agreed. Additionally, to the extent that the division failed to adequately consider the environmental impacts of the transaction in accordance with the 2021 Act on Climate, this provides the Attorney General with an additional ground upon which to challenge the division's order on the merits. So when Judge Stern held that in his motion to stay. What he was really doing there was saying, listen, if I'm gonna stay this transaction, I've gotta be convinced that the Attorney General is likely to win, right? I'm not gonna stop this if the Attorney General is likely to lose. So when he's making these statements, that's the context in which he's making them. As Judge Stern pointed out, section 42-6.2-9 of the Act on Climate sets out specific decarbonization goals for the state, including a 45% reduction in greenhouse gas emissions from 1990 levels by 2030. Importantly, the Act on Climate requires all state agencies, including quasi-public agencies, to conduct their regular business with the achievement of these goals in mind. Thus, in accordance with the Act, the division is required to consider the climate impacts of the transaction. And to the extent they fail to do so, provides the petitioner, that would be us, with yet another basis to challenge the order on the merits. The failure of the DPUC to think as broadly as they could have, and I would argue should have, about the Act on Climate, was one of the principal reasons we appealed that decision. All right, so now let's get to what has been achieved. So first, with respect to Rhode Islanders as consumers and as ratepayers. Under the DPUC decision, there will be no distribution rate increase for 3 years, and we have built on that. There is a $50 million combined rate credit for gas and electric customers. There is a $43.5 million in discharge of bad debt for accounts that are due and owing, but are unlikely to be recovered. And as ratepayers, eventually, we're gonna all be paying for those. There's also a commitment to maintain national grids programs to work with at-risk customers to ensure that their bills remain getting paid. And that was a result of some litigation that was brought a few years ago. We required a commitment that that work continue to happen to make sure that those customers find ways to keep their power on. That's good for them, and it's good for ratepayers and Rhode Islanders generally. The DPUC decision would have allowed for cost recovery of up to $103 million from ratepayers for IT systems and a local gas facility that would not have been built had National Grid retained ownership of the utility. It also involved prior spending on projects that are no longer needed. So under the DPU's decision, it was $103 million in costs that could have been recovered from us as Rhode Islanders as ratepayers. And as a condition of our agreement with PPL, they now cannot seek to recover those costs. With respect to Act on Climate, what the DPUC required was for PPL to submit a report 12 months from now, some goals for the Act on Climate. And respectfully, in our view, that's not good enough. We can't wait 12 months for a report with no guidelines as to what that report should contain if we're serious about meeting our goals. The law requires it, our future requires it. So we asked and have achieved more. So with respect and there are several components to this, and they're on a series of slides here. So with respect to renewable energy, to maintain the timelines for projects connecting to the grid and make the best efforts to improve the process as soon as practicable. What we hear a lot is that getting renewable energy resources connected to the grid is too time consuming. We're really gonna hold their feet to the fire on this. A guarantee that costs for new smart meters will not exceed the National Grid estimates already in place. And $2.5 million to be contributed to the Renewable Energy Fund, which is maintained by the Department of Commerce to fund these projects. This is really important. Under our agreement, every time PPL makes a filing in Rhode Island, whether that be before the DPUC or the PUC, they have to submit an impact statement for how that utility filing will impact the Act on Climate goals. So we're not talking about theory anymore. We're not talking about general statements. We're not talking about an end of the year report. We're talking about every time they want to do something, they've got to take the Act on Climate into account. That is long overdue, and it's gonna happen now. With respect to the Act on Climate report itself, in our view, as I mentioned, that report has to have concrete things in it. And so we've required that. The first is that they engage a consultant to author the report. If you don't bring experts in, you're not gonna have much of a product at the end. To involve stakeholders, Rhode Islanders, in the report development process. To analyze the use of energy efficiency programs and to study the capability for solar growth and electric storage. The latter one is important. It's something that Senator Don Oyer brought to my particular attention. If we want to convert to renewable energy sources, we've got to start planning as to how we're going to deliver them. And this is one aspect or one way in which we can do that. This is also important. We anticipate, we believe, that there will be opened on the PUC docket a gas docket for the future of our gas infrastructure. So we required PPL not to oppose that PUC docket and provide up to $2.5 million to this office for experts to participate both in the report and in a PUC future of gas docket. Why is that important? Well, I would argue that we have terrific lawyers in this office, okay? But our lawyers in everything we do, from healthcare to consumer protection, to lead paint, you name it, requires the use of experts. And our expert budget, as given to us by the General Assembly, is less than $1 million per year for everything that we do. It used to be less, it used to be around $60,000. We had that increased recently to $750,000. But we can't represent you as Rhode Islanders unless we have the expertise, particularly in complicated areas, to get that done. So now we will be in a position to better advocate for Rhode Islanders. So this future of gas, I'm going to talk a little more about this. It's really important. We've got to figure out how our gas future intersects with our climate future in a way that preserves the natural resources and the climate, but also make sure that Rhode Islanders are getting adequate and efficient energy. And so this will be, we anticipate that this will be a public process with our participation, PPL obviously, and other stakeholders. It's an opportunity to really study the current system, understand how we can maintain efficient and effective service while we transition, while ensuring that future ratepayers are not saddled with the costs of transition. Again, when you're talking about a monopoly, regulators and advocates have to carefully make sure that Rhode Islanders don't pay the costs of these kinds of transition projects. And we anticipate this to be an expansive, a really expansive process. This is not just going to be, cursory. It's going to take a lot of work. Now we're prepared to do it. Storm response. This is something that really concerned me, and it's why I highlighted the difference in size of these companies. The reality is we've all been around for hurricane season and the winter storm season, and we see as these tracks come up the coast, sometimes they're headed for Rhode Island, sometimes they're headed for the Cape, sometimes they're headed for Connecticut. The advantage of being in National Grid's 20 million customer network is that if the storm hits here as opposed to on the Cape, or it's worse here as opposed to on the Cape, or New York, they can surge services here. They can surge crews here to get us back online faster. It's really worried that when you untether Narragansett Electric, and remember, PPL is in Kentucky and in Pennsylvania, you've got to rely on them to get here. That could slow down storm response. And so we've required PPL to enter into a mutual aid agreement with National Grid so that mass crews will be available to Rhode Island before any other state in the event of a storm event. And that should address some of this concern. So where does that leave us? The agreement is binding on PPL, as I said. It can be enforced in court if necessary. As a result of the agreement, we've agreed to withdraw our appeal of the DPUC approval, and our office will now begin to work with experts both on the anticipated report, but also the future of gas docket. This is a team that worked on this case in the office, and it is, their work is just outstanding. This was not an easy process. I'll be candid, the DPUC did not make it easy for us. And there was an element of this in Judge Stern's decision about the focus from the DPUC on expediency, going fast, and not placing too much of a burden on the energy companies. So I think there was a real reluctance to have this office involved in those proceedings. We were given short timelines, for example. And this team met every one of those deadlines. This team worked really hard to advocate on behalf of the people of the state of Rhode Island. And I will tell you something, no one can place too big a burden before this office to prevent us from doing the right thing and fighting for Rhode Islanders. And that was the case here. So I want to thank Miriam, who's here with me, Sarah Rice, who I mentioned, who I think is on a plane, but coming back soon, I hope, to Rhode Island, Allison Hoffman, who I see is sitting back here, did a great job, Nick Vaz, who's up here with us, Tiffany Parentow, who did this work, and Ellen Gold, who we can't do anything without Ellen steering us in the right direction and getting our work done in a fast and efficient way. The PPL agreement is available on riag.ri.gov. And so with that, I'll take any questions that you have. Yes?
Yeah, when do you plan to open the gas docket?
Well, that will really be a function of the PUC. So we want to make sure that the PUC is prepared to open the gas docket, but I anticipate that it'll happen sometime in the relatively near future. I don't control that, but I anticipate that happening.
Soon?
Yes. I think everything has to be soon when we're talking about this issue. You know, we can't wait 6 months, 8 months, 2 years. That was what really struck me about the decision. The DPUC decision really seemed to suggest that, look, somebody else can deal with climate, that can be dealt with down the road. And my response was, and is, that we don't have that kind of time. You know, we said look, we need to do it in the absence of the Act on Climate. But now we've got the Act on Climate. That sets goals for us. We need to meet them, or there are consequences if we don't. Other questions? Yes.
Was there anything you were looking to get out of the settlement that you weren't able to?
Yeah, look, you know, I think that whenever you are negotiating something, you know, you have goals and you get to a place where you're comfortable. I will say this, I feel much better about where we are for the reasons I articulated than where we were when we came out of that DPUC approval process. Because remember, coming out of that process, Act on Climate had been ignored. We're talking about $103 million in recovery of costs that PPL could have gone after ratepayers for, and there was around the same number, nearly $100 million of rate credits and other forgiveness of arrearages that we were able to obtain. So when you put all that together, you talk about $200 million in effective value for Rhode Islanders and getting the Act on Climate taken seriously, that's a significant step forward in my mind. Yes, Richard?
Is this the first time that the Act on Climate has been enshrined into the legal proceedings for utility moving forward?
Yes, Richard. In fact, it's the first time that a judicial officer, in this case Judge Stern, has acknowledged the Act on Climate as something that all state agencies, can't kick it over to EC4. You can't kick it over to somebody else and say, let them deal with it. Every state agency that's making a decision that impacts climate has to take those goals into account. Now, that's an important part of Judge Stern's decision. And if you noted in the EFSB decision, requiring a full review for the C3 LNG expansion down in the Port of Providence, they found the same thing. They found that the EFSB, and they had no problem with it, need to take Act on Climate into account when they're issuing their decision, when they reach their ultimate decision. So we have made significant steps here, in this case, through Judge Stern's stay decision, and then in the EFSB decision as well from a few weeks ago. So
just to expand on that, how does that play out in the future in terms of your ability to be the environmental advocate in this? This then sets a precedent for you to be able to do more good work?
Well, listen, I like to think, and I appreciate the question, that we're doing that work now. Where I feel that we need to get involved, then we're going to get involved. You know, it doesn't matter whether it's healthcare. When the Health Services Council approves a prospect transaction, I think that's a real problem, but we're going to get involved. When the CRMC makes decisions that are at best head scratchers, we're going to get involved. And where the DPUC makes decisions that I think don't serve the people of Rhode Island well, as I believe they did in this case, then we're going to get involved because that's our job. We're going to fight for Rhode Islanders every day. You know, the way we approach things here is we see a problem and we try to see whether our tools are able to address it. And the beauty of this job is that the tools are there if you just have the will to use them. Because of this great group, we have the will and the ability to use them effectively. And I believe that's the case here. I'm gonna kind of go over here and then I'll come back to you. Yes, go ahead.
Do you think that this settlement is a better deal than if Judge Stern had granted the petition for judicial review and sent the whole case back to the DPUC?
I do,
Why?
because it's one of the reasons I went through the decision as carefully as I did. Because I think that had this gone back to the DPUC, with potentially the same hearing officer, I don't think we'd have the agreement that we were able to get from this office. Now, unless there was a sea change in approach, and I have no reason to believe that there would have been, this was the best possible outcome for Rhode Islanders, doing it this way.
Just a quick question, the 200 million, is that in excess of what was agreed to under the decision?
Yes,
In excess of?
correct,
Okay, all right.
correct. So there were no rate credits in the original decision. There were no rate credits. Here's nearly $100 million in rate credits. This is an additional $103 million of potential cost recoveries that the DPUC order would have allowed, that we have now foreclosed by virtue of this agreement.
So the 200 million is in addition to?
That's correct.
Okay.
That is correct. Yes.
I know you touched on this in a bunch of the slides, but kind of in layman's terms, what does this mean for ratepayers here in Rhode Island?
Yeah, look, I mean, it forecloses. Look, rates are complicated. There are a number of components to it. There are really three components to it. What it means for ratepayers is that we all know we're living in a high energy cost environment. What this agreement does is it really makes sure it doesn't get worse, right? There's millions of dollars here that would have been coming from ratepayers had we not been able to achieve the results that we did by, frankly, fighting the way that we did. So it's a good day for Rhode Islanders, both in terms of their rates, but also in terms of their climate. Look, we've got to be concerned about rates. We're all concerned about rates. We all get those bills. We open them up. For many Rhode Islanders, they are substantial. Substantial part of their monthly budget, no question about it. But we've got to think about the Act on Climate. We have to do something about climate change. We have to follow the law, because if we don't, our future is grim. If we take the steps we are capable of taking and do take them, and take it seriously, we can get there. But the first thing we need to do is take it seriously. And we can't just punt it to some other state agency and see if they'll let them worry about it. Yes?
Me? Oh,
Yes.
awesome. So there are 3 short years until those rates could increase, and for many families, like you said, it's a huge burden on them already. 3 years ago, it was 2019, which really wasn't that long ago.
Mm-hmm.
So for increasing rates in just 3 years, what would you tell those families?
Yeah, look, I don't know that they're gonna go up. And if there is an application for a rate increase, we'll be right there fighting on behalf of Rhode Islanders. So what I would say to those families is, you got an attorney general who's fighting for them. Got them $200 million in value today, protecting the environment for them and their families, and we're gonna keep fighting for them. That's what I'd say to those Rhode Islanders. Other questions?
A different topic, if everybody's done with this one, the truck toll trial began today. Wondering if you have any comments?
I don't. It's ongoing litigation, and we're defending the state in that action, and we will see how it goes. All right. With that, thank you all for coming. Good to see you all.